Hi friends, my name is Amit Jyoti. I am an assistant professor at the OP Jindal Global University. In this module, we shall continue with our discussion on the decisions given by the European Courts of Human Rights. Here, the first case is Opus versus Turkey, decided in June 2009. A lady first filed this case when her husband inflicted life-threatening violence against her and her mother, which resulted in the death of the latter, but no appropriate action was taken by the Turkish judicial system. The incidents had included beatings, an attempt to run the two women down with a car that had left the mother seriously injured, and an assault in which the applicant was stabbed 7 times. The authorities had been aware of the perpetrator's history of violence. A few proceedings were initiated against the husband, but he would be released in some time on one or the other ground. This was the first judgment of the court on domestic violence, where it found a violation of Articles 2, which is right to life, Article 3, prohibition of torture and ill treatment, and 14 of prohibition of discrimination. The court held that the authorities failed to perform their positive obligation to protect the right to life of person, where there existed a real and imminent risk to her life from reasonably foreseeable criminal acts of a third party. Despite the pattern of violence and use of lethal weapons, the authorities had repeatedly dropped the proceedings against the husband in order to avoid interfering in what they perceived to be a family matter. The state failed in satisfying its positive obligations with regard to protection from domestic violence. The authorities could have ordered protective measures under the Family Protection Act or issued an injunction restraining the husband from contacting, communicating with, or approaching the applicant's mother, or entering the defined areas, but they had not displayed due diligence, which resulted in the death of the applicant's mother. The criminal system of Turkey was found to be not deterrent enough to deal with this situation. Therefore, the court noted that under the relevant rules and principles of international law that were accepted by the vast majority of states, a failure, even if unintentional, by the state to protect women against domestic violence breached their right to the equal protection of law. The general and discriminatory judicial passivity in Turkey created a climate that was conducive to domestic violence against women. Condemning the overall unresponsiveness of the Turkish judicial system, the court awarded 30,000 euros in respect of non-pecuniary damage to the applicant. The next case is Kamila, Isawa versus Russia, decided on 15th November 2007. In this case, the applicant had lodged applications with the court complaining of disappearance and death or presumed death of Mr. Isawa during Russian military operations in Chechnya. Although criminal investigations had been launched, they were still pending several years later, and there had been no prosecutions. Following the communication of the case, the government were repeatedly asked for copies of the criminal investigation files. However, they declined to produce certain documents on the grounds that their disclosure would violate Article 161 of the Russian Code of Criminal Procedure, as the documents concerned contained information of a military nature or personal data on witnesses and other participants in the criminal proceedings. The court found violations of Article 2, which is substantive and procedural limbs, Article 3, 5 and 13 in conjunction with Article 2. The court held that the state's obligation to protect the right to life and in respect of the failure to conduct an effective investigation into the circumstances in which Mr. Isawa disappeared is violation of the convention. The applicant was awarded sums in respect of pecuniary and non-pecuniary damage. Next is the case of Alsamari versus the former Yugoslav Republic of Macedonia, decided on December 13, 2012. In this case, a German national of Lebanese origin alleged that on 31st December 2003, he boarded a bus for Skopje. At the Macedonian border, a suspicion arose as to the validity of his passport. He was questioned by the Macedonian authorities about possible ties with several Islamic organizations and groups. He was arrested and tortured in Skopje, then transferred by the CIA to a secret place of detention in Afghanistan, where he was held for 5 months. On 29th May 2004, the applicant was returned to Germany via Albania, and in October 2008, the applicant launched a criminal complaint with the Skopje Police Prosecutor's Office. But this was rejected as being unsubstantiated. The court found violations of Article 3, 5, 8 and 13 of the Convention and held that the former Yugoslav Republic of Macedonia had been responsible for his torture and ill treatment both in the country itself and after his transfer to the US authorities in the context of an extrajudicial retention. It held that the state had not conducted an effective investigation into the applicant's allegations of ill treatment, and therefore his detention was arbitrary. The court awarded the applicant 60,000 euros in respect of non-pecuniary damage under Article 41 of the Convention. The next case is Salmani versus France, decided on 28 July 1999. Ahmed Salmani complained of assaults on him while in police custody in Bobigny from 25th to 29th November 1991. A judicial investigation was opened against him where the judge transferred it to a judge attached to the Versailles Tribunal de Grande Instance in the interest of the proper administration of justice. The court sentenced the guilty police officers. The applicant complained that on account of ill treatment which he alleged he had suffered during the police custody and the length of the proceedings relating to his criminal complaint and application to join the proceedings as a civil party, there had been a violation of Article 3 of the European Convention on Human Rights, which prohibits torture and inhuman and degrading treatment, and of Article 6(1) of the Convention, which guarantees the right to a decision on civil rights and obligations within a reasonable time. The court found elements which were sufficiently serious to render such treatment inhuman and degrading. The court also observed that the applicant had been subjected to a certain number of acts which would have been heinous and humiliating for anyone irrespective of their condition. The court noted that these events had not been confined to any one period of police custody during which, without this in any way justifying them, heightened tension and emotions might have led to such excesses. It had been clearly established that Mr. Salmani had endured repeated and sustained assaults over a number of days of questioning, and such conduct had been regarded as acts of torture for the purposes of Article 3 of the Convention. The court considered that the reasonable time prescribed by Article 6(1) had been exceeded, as the proceedings were still pending in appeal and already 6 years and 7 months had lapsed. Therefore, the court awarded damages to the applicant and emphasized the need for breaches of the fundamental values of democratic societies to be assessed even more stringently, with the rising level of expectation for protection of human rights and fundamental freedoms. The next case is Balayan versus Armenia, decided on 7 July 2001. This case concerned a Jehovah's Witness who had been declared fit for military service. When he informed the authorities that he had not served in the military on conscious grounds but was ready to carry out alternate civil service. On January 25, 2001, when Armenia joined the Council of Europe, it took to introduce civilian service as an alternative to compulsory military service within 3 years, and to pardon all conscientious objectors sentenced to imprisonment. In May 2001, when Jehovah's Witness, the applicant here, was summoned to commence his military service, he failed to report for duty and temporarily left his home for fear of being forcibly taken to the military. He was charged with draft evasion and in 2002 was sentenced to 2.5 years imprisonment. He was released on parole after serving about 10.5 months of his sentence. At the material time in Armenia, there was no law offering alternative civil service for conscientious objectors. This was the first case under Article 9, which talks about freedom of thought, conscience and religion of the Convention, before the court, where it examined its applicability to the conscientious objectors. When the applicant was released from imprisonment, Armenia had recognized the right to conscientious objection. On deciding the applicability of Article 9 in this situation, the court held that although Article 9 did not explicitly refer to a right to a conscientious objection, opposition to military service motivated by a serious and insurmountable conflict between the obligation to serve in the army and an individual's conscience or deeply and genuinely held religious or other beliefs constituted a conviction or belief of sufficient cogency, seriousness, cohesion and importance to interact the guarantees of Article 9. The applicant in this case did not report for military service owing to his religious manifestations. Imposition of criminal sanctions in such situation cannot be regarded as necessary for democratic society. Lastly, applicant's prosecution and conviction by the authorities in Armenia only took place after Armenia had acceded to the Council of Europe. Therefore, Armenia was in violation of Article 9 and was asked to pay 10,000 euros in respect of non-pecuniary damage to the applicant. Next case is Alexandria versus Greece, decided on 21st February 2008. When the applicant was admitted to practice as a lawyer at a court of first instance, he had to take an oath of office, which according to the national legislation was a religious oath. He was obliged to declare that he was an atheist or that his religion did not permit him to take an oath. The court secretariat provided him with a form containing a standard text of the oath, which he submitted to the president of the court. When the president asked him to place his right hand on the Bible and to take the oath, he had informed her that he was not an Orthodox Christian and therefore wanted to make a solemn declaration, which he had been allowed to do. The Greek government stated that there were two different forms, one for the religious oath and other for a solemn declaration. The applicant had not asked for the correct form and had filled out the form used for the religious oath. The government mentioned that the applicant had indeed taken the form for religious oaths with him when he appeared before the president of the court, but had then requested permission to make a solemn declaration. He had made no attempt to have the document rectified subsequently. The court in this case held that in the case the procedure for taking oaths reflected a presumption that lawyers going before the court were Orthodox Christians and wished to take the religious oath. Hence, when the applicant went before the court, he had been obliged to declare that he was not an Orthodox Christian, and hence to reveal in part his religious beliefs in order to be allowed to make a solemn declaration. The state authorities did not have the right to intervene in the sphere of individual conscience and to ascertain individuals' religious belief or oblige them to reveal their beliefs concerning spiritual matters. From the given evidence, the court was unable to conclude that two forms had existed at the material time. There was violation of Article 9 because of the fact that applicant had to reveal to the court that he was not an Orthodox Christian and that he wanted to make a solemn declaration rather than take the religious oath had interfered with his freedom not to have a manifest to his own religious beliefs. The next case is Nagla versus Latvia, decided on 16 July 2013. In this case, the applicant worked for the national television broadcaster where she produced and hosted a weekly investigative news program which was titled as De facto. In February 2010, she informed the public of an information leak from the State Revenue Service database on the basis of the information received from an anonymous source. The VID initiated criminal proceedings against the source called Neo as he had published the information concerning the salaries of state officials in various public institutions. The investigating police interviewed the applicant as a witness, but she refused to disclose the identity of her source. The investigating police searched applicant's house and seized a laptop, an external hard drive, a memory card and 4 flash drives on the basis of a search warrant. The court found a violation of Article 10, which talks of freedom of expression, emphasizing that the right of journalists not to disclose their sources could not be considered a privilege, dependent on the lawfulness or unlawfulness of their sources, but rather as an intrinsic part of the right to information. The court found that there had been interference with the applicant's freedom to receive and impart information, which interference was prescribed by law, and pursued the aim of preventing disorder or crime or protecting the rights of others. The search and seizure warrant, on the basis of which the authorities exercised their powers, was rather vaguely drafted. The right of journalists not to disclose their sources was important, as it kept the public informed about the salaries paid in the public sector at a time of economic crisis and about the database of the VIT. While proceeding with the operation, the authorities did not examine the proportionality between the public interest in the investigation and the protection of the journalist's freedom of expression. Such urgent search warrant could be carried out to prevent the destruction, concealment, or damaging of evidence. Applicant was only a witness with respect to the criminal proceedings against the source. Therefore, authorities had failed to give relevant and sufficient reasons for the interference complained of and were asked to pay 10,000 euros in respect of non-pecuniary damage. The next case is Hirsajama and others versus Italy, decided on 23rd February 2012. A group of migrants, that is 11 Somalis and 13 Eritrean nationals coming from Libya, as a part of a group of about 200 individuals, filed an application before the European Court. The group boarded 3 vessels with the aim of reaching the Italian coast, but while within the Maltese search and rescue region of responsibility, they were intercepted by ships from the Italian Revenue Police and the Coast Guard. Then they were transferred onto Italian military ships and returned to Tripoli. During the voyage, no efforts were made to identify the group, and they were not informed about their destination, but were finally forcefully handed over to the Libyan authorities. 2 of the applicants died in unknown circumstances after the events in question, and 14 of the applicants were granted refugee status by the Office of the High Commissioner for Refugees in Tripoli between June and October 2009. The court held that despite the complex migrant situation, states are not absolved of their obligation not to remove an individual at risk of being subjected to treatment in breach of Article 3 in the receiving country. The court concluded that by transferring the applicants to Libya, the Italian authorities had, in full knowledge of the facts, exposed them to the treatment prescribed by the Convention. While assessing the risk of ill treatment in the applicants' countries of origin, the court held that when the applicants were transferred to Libya, the Italian authorities had or should have known that there were insufficient guarantees protecting them from the risk of being arbitrarily returned to their respective countries of origin. The court, for the first time, held that there was a breach of Article 4 of Protocol number 4 to the European Convention to a case involving the removal of aliens to a third state carried out outside national territory. The transfer of the immigrants to Libya without any examination of each individual situation had exposed them to the risk of ill treatment and had constituted a collective expulsion under the said provision of the convention. The court held that the Italian government had to take all possible steps to obtain assurances from the Libyan authorities that the applicants would not be subjected to treatment incompatible with Article 3 of the Convention or arbitrarily repatriated. With this, we end our discussion of the European Court of Human Rights. Thank you for listening.